Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. The FDA recently issued new draft guidance clarifying how the agency evaluates whether a flavored nicotine vaping product is appropriate for the protection of public health. And when we say flavored, we mean non-tobacco flavored vapes. Your fruit flavors, dessert flavors, the most popular flavors on the market. With youth vaping in sharp decline and youth smoking rates so low they barely register, it raises the question, is the FDA finally ready to allow adult vapers meaningful access to these products? Joining us today to help answer that question is Azim Chowdhury from the firm Keller & Heckman. Azim is a regulatory and public policy lawyer with a focus on food and drug law. He's the editor and lead voice behind The Continuum of Risk, the top industry blog on legal affairs. And he's the lead organizer of Keller & Heckman's 10th annual E-Vapor, Nicotine, and Tobacco Law Symposium, coming up this May 4th and 5th in Las Vegas. Azim, it's great to see you again. Thanks for coming back on the show.
Hey, Brent. It's been a while, and it's great to be back.
So walk us through the upcoming symposium. Who is it designed for, and what are the key issues you're focusing on?
Yeah, sure. As you mentioned, this is our 10th annual symposium, which is an exciting milestone for us. It is designed for businesses and professionals who have to navigate this regulatory system every day. Manufacturers, suppliers, distributors, retailers, investors, and lawyers, among others, scientists as well. As always, our focus is compliance, helping companies understand the ever complex federal, state, and international rules, from FDA's new guidance that you mentioned to federal and state enforcement actions, PMTA and MRTP pathways, the ongoing MDO litigation, PACT Act issues, environmental compliance, among others. This year, we are covering topics such as oral nicotine, device access restriction technology, nicotine analogs, and of course, the fast-moving state and international developments. So in short, the symposium is designed to be a survival guide for companies who are operating in this rapidly changing market. And I'll just note that in addition to the Keller & Heckman attorneys presenting, we have a number of amazing industry and scientific experts who will be speaking again. All the details can be found on the agenda.
And so there's still a chance for people to get tickets?
Yes, definitely. Registration is still open through the month of April.
So Azim, if you could you give our viewers a snapshot of the challenges the U.S. vaping industry has faced over the past 5 or 6 years?
Sure. The biggest challenge, I would say, has been the prolonged regulatory uncertainty combined with an extraordinarily high bar for authorization. Companies have spent millions trying to comply, yet very few products, in particular flavors, have actually made it through the PMTA process with FDA. At the same time, businesses have faced federal and state enforcement, import seizures, private litigation, and now an expanding patchwork of state laws. So the result is a market where lawful operators or companies who are trying to be lawful are squeezed, and smaller businesses are shutting down while the illicit market continues to grow.
So basically, it has been difficult or even impossible to get flavored ends products authorized.
Correct. At this point in time, FDA has authorized, they say a total of 41 products. It's really a smaller number of actual products and their components. But the only flavors we have other than tobacco are a couple of menthol authorizations for Enjoy products, and last year the Juul menthol pod. So other than that, no actual flavors.
I want to ask you about last year's Supreme Court ruling in FDA versus wages and white line investments. There was considerable hope the justices would side with the industry and rule that the FDA acted arbitrarily and capriciously when it denied marketing orders for flavored e-liquids from Vapetasia and Triton Distribution. Azim, what happened there?
Yeah, great question. Well, the court did side with FDA and held that the agency had not acted arbitrarily and capriciously in denying Triton's flavored applications, at least on the core question of whether the FDA had changed its position without fair notice with respect to the comparative efficacy study requirement for flavored products. So, in other words, the court concluded that FDA had not promised one standard and then secretly applied another. However, I will mention that the court did not resolve every issue in that case. And so the case was actually remanded back to the Fifth Circuit for further consideration. And there are several other cases now pending in that circuit and others. So there are still broader challenges to the FDA's PMTA framework that are still very much alive.
Yeah, and I mean, obviously, this issue around the switcheroo, when the U.S. Court of Appeals for the Fifth Circuit first heard the case, and they said that the FDA, quote, sent manufacturers of flavored e-cigarette products on a wild goose chase by issuing guidance on which the companies relied on in preparing their applications, only to later nullify that advice through what the appeals court called regulatory switcheroos. But in the Supreme Court ruling, Justice Alito noted that, in the respondent's view, the FDA initially said manufacturers would not need to provide specific kinds of studies, like randomized control trials or longitudinal cohort studies, but then treated such evidence as essential. However, Justice Alito ultimately wrote that, quote, "We cannot agree with their argument that the FDA went back on any commitments made in the guidance it provided before ruling on the respondents' applications." So, Azim, I mean, what do you make of that? Because it seems to me that that was a wholesale rejection of the switcheroo.
Yeah, it was effectively. I think Justice Alito's point was that applicants may have been understandably frustrated, but that frustration is not the same thing as a legally actionable change in position. So effectively, the court treated FDA's comparative efficacy approach as really a sufficiently predictable outgrowth of its earlier guidance. So companies, and I don't agree with this, obviously, this holding, but so companies should have been able, in the court's view, to have been able to predict that FDA was going to want to see this type of comparison data for flavors compared to tobacco flavors based on its earlier guidance, its focus, for example, in 2020, in the enforcement guidance on sweet flavors, right, and that they identified those as being a higher risk for youth. But from an industry's perspective, the result was disappointing because many companies believed they were told one thing and then judged by something more demanding, right, that was not made clear before. But I think the Supreme Court's position was that FDA's approach was consistent enough with its prior guidance to survive the case.
Do you think SCOTUS made the right ruling there?
No, I don't. I think there's a lot of flaws in its ruling. I think that a lot of folks thought this was going to be a sweeping anti-agency decision. That wasn't the case here. It was a much more narrow decision. And as I mentioned, there are still a number of issues that were not resolved by the Supreme Court that are still pending in the Fifth Circuit and other circuits. So we're involved in some of those cases. I can't get into too much detail, but considering those are pending litigation. But I will say that there are still arguments being made that FDA has taken the wrong approach here.
Yeah, I guess that's the kind of the last follow-up on this is that what can you share with us about those issues that got kicked back down to the lower courts?
Yeah, so among other things, one question is with respect to the marketing plans. Was FDA made a big deal leading up to the PMTA submissions that how a company markets their products, what efforts they're making to prevent youth access, would be a key consideration, a key factor in the PMTA review. And of course, with the fatal flaw approach, none of that was considered. And so That's one issue that has been remanded, whether there was harmless error in denying applications without completely reviewing the marketing plans. There are the issue of rulemaking. Companies are still arguing that FDA effectively, by requiring an across the board um, requirement as described in the MDOs for this comparative efficacy study, that was effectively a rulemaking without notice and comment, and that therefore, it was a violation of the APA. There's also arguments regarding the fact that what the result of all this is a de facto flavor ban. The Supreme Court didn't actually make a holding on that point. That there was in fact a de facto ban on flavors, even if we have a couple of menthol authorizations. That doesn't mean there wasn't a de facto ban, which again is another example of potentially arbitrary rulemaking or arbitrary decision without rulemaking.
And let me ask you, I guess, lastly on this is that for myself, I had hoped several of the justices would see this case as an opportunity to deliver a major blow to the administrative state. Instead, they sanctioned FDA's behavior here. Is that the wrong way to see it?
Yeah, I think a lot of folks were hoping that was the case. I think it was always unlikely that a case about vaping would kind of, lead the charge on the administrative state concerns. But again, as I mentioned before, I think essentially the court said that as long as FDA remained tied to its statutory public health mission, it has significant room to make these kinds of scientific and policy judgments. But again, there's still arguments out there that perhaps FDA has gone too far.
So why should any company invest millions of dollars in regulatory compliance when the rules can change midstream? And the courts have now upheld that approach.
Yeah, that is exactly why so many companies continue to be frustrated. Like businesses are willing to invest in science, manufacturing, and compliance, but they need a process that is predictable enough to justify that investment. And right now, the PMT is so expensive and it's slow and it's heavily dependent on agency discretion, as I mentioned, without product standards. And so without more clear rules of the road, I think compliance starts to look less like a actual pathway and more like a gamble. And so right now, in my view, the FDA is not doing enough to incentivize companies to actually participate in that process and try to compete with the illicit market.
FDA does seem to be supportive of the nicotine pouch route, though.
That's true. So we have, in terms of total number of authorizations and flavors, we are definitely seeing FDA recognizing the benefits of flavors with respect to pouches. They've authorized the Zyn pouch in several flavors, and more recently, the On Plus in several flavors. And so, it does appear FDA is more willing to grant authorizations for flavored pouches. We also saw last year that they implemented this pilot program for nicotine pouches, whereby they were streamlining the review of certain applications that were still pending for many years. So the On Plus application that was authorized appears to be the first one so far that came out of that pilot program. There may be others in the future.
So Azim, clearly, I guess that nicotine pouches, they seem to be able to get authorized easier with flavors. So why has it been so difficult for U.S. vaping companies to obtain marketing orders for their flavored products?
Pouches are really a totally different category, and there's very different public health concerns relative to vaping, right? So obviously the product category is different. You're not dealing with inhalation of substances into your lungs. So it's a very different risk profile versus what is consumed in the mouth and absorbed in the mouth. Then you also have the fact that to date, so far, there has not been a youth pouch concern, right? So to the extent the youth vaping crisis of 2019 kind of drove FDA towards this path of focusing on flavors and comparative efficacy, we haven't had that issue yet. So even though vaping rates are significantly lower today than they were in 2019, with respect to pouches, we don't have that issue. I think the most recent NYTS results indicate that pouch use remains very low, less than 2% amongst high schoolers and middle schoolers. So I think for that reason, FDA is appropriately, weighing the evidence of reduced harm for adults for pouches. And my hope is that given how youth vaping has fallen so dramatically over the last several years, they will adjust and do the same for vaping.
Does the FDA control the definition of appropriate for the protection of public health, or is that defined by Congress?
The APPH standard was defined by Congress, so it is in the Tobacco Control Act itself. And Section 910 of that act is what requires FDA to evaluate the risks and benefits to the population as a whole, including both users and non-users. And it requires FDA to consider things like the overall impact on initiation and cessation at the population level. So in that sense, it is a very demanding standard. In my opinion, APPH is actually a higher standard than the safe and effective framework used for drugs, because not only does a tobacco company or a nicotine company have to demonstrate the individual, safety of the product to the consumer, but they also have to address this population level impact. So again, FDA does not control the statutory language, but it does have substantial discretion in deciding what evidence is sufficient to satisfy it.
So they do have much room to maneuver around that.
Yes, and as we can see from these guidance documents that have come out recently, the goalposts are often moving with respect to the evidence required.
FDA's new draft guidance on flavors does make it seem a bit easier, or is it harder to obtain marketing orders for flavored products?
I would not say that the new guidance has made the process easier. What it does is make FDA's current thinking more explicit. So as we discussed, the agency is still using tobacco flavor as the baseline comparator, and it is still placing the greatest evidentiary burden on flavors that FDA believes are the most appealing to youth. So the guidance adds clarity, but it doesn't fundamentally open the door for flavored products. In fact, I think it makes it more clear that the flavors that adults enjoy most are going to have the toughest time to get authorized.
Right. So the frameworks rank flavors like fruit and dessert flavors with the highest evidentiary burden in terms of this, proving and comparing it to tobacco flavored vapes, which seems crazy. Why aren't they, comparing it to cigarettes?
Right. I think that is one of the most important takeaways from the guidance. FDA is effectively saying that not all flavors are treated the same. The more a flavor is perceived to attract youth or be attractive to youth, the more evidence will be required to justify marketing that flavor. So that means, fruit, dessert, and other sweet flavors face the steepest climb. Whereas more, I guess, mature flavor profiles like menthol and potentially categories such as coffee, spice, tea, which by the way are not easy flavors to find on the market compared to the fruit flavors. But those types of flavors may have a lower burden.
Did they break it down, in a way that is based on sweetness?
I think the bottom line is, FDA is given a broad range of categories that they consider more likely to appeal to youth. And it's up to, if the company has a sweet tea and they're not sure if that's in the low risk category or the high risk category, FDA's, wants you to make, wants you to meet with them and justify the approach that you're taking. Right. So there's no clear answer. It's up to the company to figure it out. And again, this goes towards our point of there just being not enough, very little clarity on how to approach this.
Well, and that is my question. What does the new draft guidance actually say about, say, types of studies needed? Did they have that nailed down and can show a difference of you need this study for mango and you need this study for tea? So
it doesn't get into that level of detail in terms of what evidence is going to be required for different types of flavors. In terms of like, there's no clear checklist, right? FDA points to clinical and behavioral evidence, observational real world data, published literature, youth appeal research, including, as you mentioned, sensory perception studies. So again, there's just a lot of information about data that might be useful, but no clear guidance on what exactly is going to be required for what flavors. It's really up to the companies, in FDA's view, to make the determination and again justify what data you are generating in your PMTA. And so that's why FDA, ideal world, FDA wants companies to meet with them, but that's also been difficult to do, and come up with a strategy that makes the most sense.
Now, call me skeptical here, but it kind of feels like that this new draft guidance is a bit of a legal backstop for their de facto flavor ban. So they have been accused by industry. Fifth Courts of Appeal use that term, in fact, to define what's happening here. Now, while SCOTUS didn't really weigh in on that issue, they're still vulnerable to this de facto flavor ban ruling. Does this guidance somehow, get their back?
Well, the guidance in a way codifies the FDA's position on, the wages case. And again, it formalizes their view that flavors in the ends category must be compared to tobacco flavors, right? This comparative efficacy standard, which we've mentioned a couple times, which in and of itself seems somewhat arbitrary.
What we're talking about here is that, in a way, the FDA is finally agreeing to all of the benefits of vaping products, nicotine vaping products, in terms of helping smokers to quit. But that's not enough if you want to, make flavored vaping products from the more desirable end. Now you have to prove that not only the baseline is that they work, they help people quit. Now you have to prove something more.
Right. You have to prove this added benefit relative to a tobacco flavor. So again, FDA's view is that tobacco flavored ends are not attractive to youth. And they're willing to authorize tobacco flavors, as we see from their list of authorized products. And so their position is, well, we know, or we presume, that non-tobacco flavors are attractive to youth. And therefore, in order to overcome that presumption of youth risk, companies must demonstrate that their flavored products have this additional benefit for adult smokers in terms of switching, getting them to switch completely to the flavored product, or in terms of reducing their cigarette consumption, right? If you're able to significantly reduce how many cigarettes an adult smokes because of the flavored product, that would also be an additional benefit. But you have to show enough sufficient benefit or additional benefit relative to a tobacco flavor that is going to be enough to overcome the presumption of youth risk. And what this guidance does is try to make more clear, for example, that, hey, now we know, according to FDA, more recent data is indicating that menthol is not that popular amongst youth. And so because menthol is not that popular amongst youth, the amount of additional benefit that may be necessary to overcome the youth risk presumption is lower, potentially, for a menthol flavored product than a fruit or dessert flavored product, which is, again, has a higher burden to prove, a higher hump, to overcome, because there's more data to suggest that kids will gravitate towards the flavored product.
Are you aware of any study that has been done that actually makes that comparison? Because most of the ones that I'm familiar with have been nicotine vaping products compared to combustible tobacco products, not fruit-flavored vaping products compared to tobacco-flavored vaping products.
Well, the study would have to be product specific study, and so that would be the kind of study that would be included in an application. And the flavored, or sorry, the menthol ENDS products that have been authorized, as I understand, have done that study, right? So FDA has approved the handful of menthol flavors because they were able to show an additional benefit relative to their tobacco flavored counterparts. And so again, it's the type of study that each company is going to have to do, which again seems somewhat redundant to require thousands of companies to do the same type of comparison of their different flavors to a tobacco flavor. But that is what is required. It is a case by case, product by product application that forces everyone to do the same types of studies and cost millions and millions of dollars.
So this is the comparative efficacy standard that you've been talking about, correct?
Yes, correct.
Now, I mean, what's wrong with that at its heart?
Well, I guess there's a couple of things that I would say that are wrong with it when it comes to ends products. Um, First and foremost, it doesn't make a lot of sense to me for tobacco flavored ends to be the baseline comparator, right? And that's because, as you know, right, tobacco flavor is just one formulation within the ends category. A product can be tobacco flavored, menthol flavored, fruit flavored, or whatever else. So it's not that these products are inherently tobacco flavored. If you took away the flavor and all you had was a, PG, VG nicotine solution, that product, that liquid would not taste like tobacco. It wouldn't taste like, smoke. Um, and so it's not a baseline, like it is for, say, a combustible cigarette or a pipe tobacco or a cigar, right? Those traditional types of products that are made with tobacco and combust tobacco um, are tobacco flavored by nature. And so when you consider flavoring those types of tobacco containing products, what you're really doing is you're adding a flavor to the baseline tobacco. And there may be reasons to do that raise public health concerns. For example, one argument against menthol cigarettes is that menthol was added to cigarettes in order to make the smoking process less harsh, right? It was going to make it easier to inhale a mentholized cigarette than a non-mentholized cigarette because that menthol, the coolness makes it easier to smoke. And so obviously that raises concerns in the public health world, as it should, because it could result in more initiation, right? Inexperienced users who are not used to smoking will find it easier potentially to smoke a menthol cigarette than a traditional tobacco cigarette. But you don't have those same concerns with ENDS products because you're not adding flavors to mask the original or the baseline tobacco flavor because there is none, right? It's not making it more or less harsh. It's just a different flavor compound or different flavor experience. Um, because again, e-liquids do not contain tobacco leaf. They don't combust tobacco or create smoke. And so again, it just seems like forcing vape products to, in many cases, compare themselves to products that they don't even have. So many companies back in 2020, when they were submitting the initial applications, did not naturally include a comparison to their tobacco flavored e-liquid, for example, because they didn't have one. They didn't sell a tobacco flavored e-liquid. That wasn't something that was on the, wasn't predominantly on the market. And so again, there's lots of reasons why it doesn't make sense. Those are a couple of them. But it seems to be a point that is not often addressed, right? It just seems, automatic that we would consider a tobacco flavor ends to be the appropriate comparator when I would say the better comparator would be to a combustible cigarette because that is the goal of the statute is to reduce harm from smoking.
Is this a good example of FDA moving the goalposts? That all of a sudden we're comparing the, fruit flavored products to, tobacco flavored vapes.
Well, again, that was the point of the MDO challenges following the denials. It was a point raised in the wages case, and um, I think the industry made the argument that the goalposts were moved, that the PMTA process was a wild goose chase without clear guidance, and without fair notice about what was going to be ultimately required. But as we discussed earlier, the Supreme Court did rule, um, for better or worse, that when it comes to whether or not there was a switcheroo or changing a position, that did not happen here.
So, with this new draft guidance, are things now crystal clear?
No, by no means. I don't think things are crystal clear. Um, Again, I think the agency it's more clear about what the FDA's theory is and about the concerns driving their decision making, with especially around youth appeal. So we kind of have a better idea of what their current thinking is, which is the point of guidance. The point of a guidance document is to make clear what their current thinking is on a particular topic. And on that point, I would just say, this is still only a draft guidance. It remains non-binding, subject to change, and leaves substantial room for FDA to decide things on a case-by-case basis where there is enough evidence. So companies, at the end of the day, now have a little more direction and understanding what FDA is thinking. So that's helpful. But again, it's not to the level of certainty that businesses would want before investing millions of dollars.
Azim, stepping outside of FDA for a moment, how would you describe what's happening at the state level right now in terms of, say, flavor bans, PMTA directories, and enforcements?
Yeah, I think at the state level, the trend is fragmentation. We see many states have now enacted flavor bans, either at the state level or at the local level. Others have adopted these PMTA or certification directory systems, whereby in order to be legally sold in that state, a product has to be on a directory, a listing that the state maintains. And to get on that state directory, for the most part, a company has to demonstrate that the product is either authorized by FDA or is subject to a pending application that is still under review, or if there's been litigation, that they have a stay of a denial. And so, again, very limited set of a subset of products that can meet those standards or thresholds. So we're seeing more of those types of directories, flavor bans, as I mentioned, increased licensing and enforcement requirements. So even if a company is able to navigate the federal process, it still has to deal with this second layer of state-by-state regulation that creates enormous complexity.
Last fall, the federal government made a big deal about enforcement, including the seizure of millions of vape products. What impact has that had on the industry?
Well, I think it's had a major chilling effect, especially for importers and distributors and retailers. High-profile seizures, I think, send a clear signal that enforcement is no longer theoretical, right? It disrupts supply chains, it raises the financial risk, it forces companies to scrutinize the sourcing and inventory much more carefully, to understand what it is that they're marketing. So even without changing the law, right, aggressive enforcement alone can reshape the market very quickly.
Now, you mentioned earlier that one of the ways some of the companies are responding to these issues is through nicotine analogs. What are they, and how are they different from the synthetic nicotine, which Congress addressed a few years back?
Yeah, synthetic nicotine is still nicotine. It's just nicotine that is not derived from tobacco, right? It's made in a lab from non-tobacco sources, but it's still chemically nicotine. And as you mentioned, initially, right, the Tobacco Control Act defined tobacco products to only cover tobacco-derived substances. And so synthetic nicotine, if it's not derived from tobacco, was outside of that requirement or definition. But then in 2022, Congress amended the definition of tobacco product to include products that contain nicotine from any source. So they closed that loophole, subjecting synthetic nicotine to the PMTA and other requirements. Nicotine analogs are different molecules, essentially. It is a different chemical that perhaps may be similar to nicotine, but is simply not chemically nicotine. Um, and so when it comes to whether or not those types of products are that contain analogs and otherwise don't contain nicotine or tobacco-derived substances, and would not fall under the component and part definition, so they're not capable of being used as a component for nicotine or tobacco products, then they would fall outside of the definition of a tobacco product and then therefore outside of, for example, the PMTA process. Um, so that's why I think we are seeing more companies explore that route. And, my recommendation would be for companies to do so carefully, to be aware of the risks both at the federal and state level. Um, I think Congress could close that loophole in the future by, again, amending the definition of tobacco to include nicotine analogs. In fact, we've seen some states do that. California, for example, their definition of nicotine includes nicotine analogs. So a nicotine analog product would be subject to California's flavor ban, for example. So anyway, it's an area that we're watching very carefully.
Azim, President Trump has twice promised to save vaping, once in his first term and again while running for his second term. Does this look like he's saving vaping?
At this point in time, I would say no, not yet. There's a real difference between political rhetoric and regulatory reality, right? The rhetoric may sound supportive of vaping, but the legal and enforcement environment remains extremely tough, especially for flavored products. So the question is whether the lawful market has become easier to navigate. The answer, since President Trump has been in office, the answer is no.
So given everything we've discussed, the FDA framework, the courts, and state-level enforcement, is there a viable path, in your opinion, forward for the U.S. vaping industry?
I think there is, but it's a narrow path, right? The companies that are most likely to survive are the ones that can produce strong science, strong manufacturing controls, that they do the work to meet FDA's current framework, even though that's evolving. But at the same time, we need reform, right? Reform is still needed. FDA needs to be much more clear about what it actually requires for PMTA. I think FDA should make significantly more use of its rulemaking powers to create product standards, so the market can be governed by more predictable rules and not just draft guidance. And it's not just shaped by litigation, for example. So I think there is a pathway, to get more products authorized that can actually have, which is, in my opinion, absolutely necessary in order to, again, incentivize companies to invest in the PMTA process and in compliance, and in order to actually have enough authorized products on the market to compete with the illicit products, and to make it, companies that I've talked to are not interested in selling illicit products. They want to be regulated, they want to be compliant, and it's just very hard for them to, again, invest in that process when they know that their competitors aren't doing so, and can make millions of dollars selling illicit products. So again, I think it's the FDA's job to get more companies involved and to incentivize companies to participate.